Good morning. I'm Mike Knight, ATE Sales Manager for ARAG Legal Services. I'm pleased to welcome our formidable panel of experts to our very first roundtable event. Before we start with the subject matter, I'd like to ask our panel to introduce themselves to the audience.
Hello there, my name is Shahram Sharghy and I'm a barrister at 9 Gough Chambers. I'm also an executive committee member of APIL and PIBA and sit on the Ogden Working Party Group.
And Steve?
Hello, I'm Stephen Webber. I'm a partner and the head of individual services at Gough Chambers Solicitors. I'm the former chairman of SCIL. I also sit on the Ogden Working Party.
Morning. Suzanne?
Hello, I'm Suzanne Trask. I'm a partner and head of the Adult Brain Injury Group at Bolt Burden Kemp. I'm also a member of the executive committee at APIL.
Thank you. Peter?
Yes, good morning. I'm Peter Walsh, Chief Executive of Action Against Medical Accidents, or AvMA for short, the patient's charity for patient safety and justice.
Thank you, Peter. And finally, last but not least, Paul.
Good morning, I'm Paul Rumley. My day job is I'm a partner and the business development lead in the clinical agents department at Royds with E. King. But today I'm here in my capacity as chairman of the Society of Clinical Injury Lawyers, otherwise known as SCIL.
Thank you and good morning to you all. Without further ado, we'll move on to the subject matter of the morning. The first subject that we're going to be discussing is the COVID pandemic. And the first question is in two parts. So the recent ARAG clinical negligence survey into the impact of COVID identified delays at most stages of clinical negligence cases. Could you discuss the practical impact of COVID, referring to the survey results and also your own personal experiences? The second part of the question, I'd also like to hear your thoughts on clinical negligence cases during the pandemic. If I could ask Suzanne that question first of all, and then move on to the rest of the panel. Thank you.
Thank you, Mike, for the introduction and for the invitation to be on the panel today. I think something that we learned pretty early on is that each of us have of course, experienced this period differently and have our own combination of challenges. People and firms are facing new situations and responding in the best way they know how. The survey shows, and it's been reported, that firms have likely to have seen a reduction in inquiries, which I'm sure we're all monitoring really carefully. And as well as that, firms are also facing delays caused by third parties, so record providers, experts and the courts. And of course, everybody's been affected by absences for sickness and other leave. We've all become far more familiar with this format with remote and video solutions. At our firm, one of the things we're fortunate about is that the vast majority of our cases are in the High Court, so they have a lower volume of cases than the county court system. And at the beginning, we did see really last-minute changes, inconsistent use of technology, hard copy documents still being needed. The limits on the types of trials that could be held remotely were learned day to day. It was really, we were finding our way as each day passed. Though I do feel we're in a better position with this now, certainly in the High Court. Some expert assessments simply can't be done by video, depending upon the medical specialty and the client, although some can, I'd say. For example, neuropsychological testing will need to be done in person, in my view, and I know that's the view shared by others. This inevitably all leads to delays to ensure adequate protection and safety for all. That's the client, the expert, their family, and other people that they're in touch with. And this time is a bit strange, and it's something that's felt every now and then like all rules are off. It's been a bit of a peculiar time, and what has been a peculiar positive of that is that it has led to, I've found, sometimes a greater flexibility between the parties and innovative solutions being reached. The APIL and FOIL best practice guide set up in March last year covered the position where the defendant is an insurance company, and the SCIL, AvMA and NHSR protocol agreed in August showed willing on both sides to find new ways forwards, and that was really helpful. We've had remote settlement meetings and mediations and made progress on narrowing issues and settled cases during lockdown. So those things have been made and proved possible in some but not all cases. So it's a mixed bag, and we've been finding our way as we've been going along, I think. Moving on to the second part of the question, so cases arising during the pandemic. First of all, I think it's absolutely crucial that I say that we have an incredible respect for doctors and medical staff during this time. The work that they're doing is very, very difficult, and you only need to look at the scenes in the intensive care units on the television and so on, where staff are looking after patients who are on their own, who aren't able to have the support of their families, and the situation is obviously just awful for them. As we know, as part of the efforts to help, medical staff are sometimes being reallocated to different roles, ones that they're not used to. And partly because of this, we've heard calls for immunity from liability, which we've all heard from different routes. However, this is something that's not currently gained traction with the government, who have essentially said that there's an indemnity scheme already available and that this will provide cover. So the question that is on our mind is, what do we ask of doctors during this time? And certainly APIL's position is that the principle of full and fair compensation remains, where somebody suffers an injury because of the fault of another. So our view is that claims and the standards of care to be expected will be judged in the context of the paramedic. And it comes down to what medical experts tell us in each case about the information available at the time and the particular environment in which the treatment was being provided. There have also been comments in the press, mostly from medical indemnity organisations, that there will be inevitably a big spike in cases. And there may be. I actually think that we'll see more claims from those indirectly affected by COVID. So those relating to a delay in diagnosis of another condition, for example, and we've seen routine cancer referrals and screening appointments put back. That's going to have an effect. The Lancet Impact Study published in July last year showed some really worrying figures on likely outcomes, which was something that we really have to think about as society as a whole, as well as clinical negligence solicitors. So those are my initial thoughts.
Thank you, Suzanne. Yeah, these are unprecedented times, and it's interesting your thoughts on what the landscape looks at the moment. If I could now move on to Paul, if you could give your thoughts on that first question, please.
Yes, I mean, I agree with everything that Suzanne's already said. You know, this is a difficult time for everyone, but I am an optimist, a realistic optimist, I hope. In terms of cases and progression of cases, as Suzanne referred to, you know, we have made a massive step forward. The COVID-19 clinical negligence claims protocol brokered with AvMA, SCIL and NHSR is a prime example of collaboration, trying to produce some real practical benefits to keep things moving forward. It has continued progress of cases and access to justice at its very heart. And so it explicitly says that those cases that can proceed should proceed, and the protocol should be relied upon in that way equally in terms of the very practical issues it tries to address. So, for example, service by email being the default, which speed things up, the limitation moratorium, which is absolutely brilliant, including in terms of not having to issue cases unless you really need to, which saves money all the way round, in particular for the health service. And also that we just get on with things, really. And I mean, the main thing I would say about the clinical negligence claims protocol, and I think probably the thing, I don't want to speak for Peter, but I think the thing that we were proudest about, not just the protocol as a whole, is the fact that it doesn't automatically lapse. It remains in place unless or until one of the signatories decides that it ends. And we have review meetings every 8 weeks. And so there isn't really a lot of incentive at the moment. Every 8 weeks, we resolve whatever practical issues there are. And of course, there are. It evolves like anything else. We resolve those. It's a very firm protocol, and whereas unfortunately some other protocols they're kind of up for renegotiation almost every 8 weeks. That's not so with this protocol, and so it's a really good one. Also under the protocol, speedier payments on account of damages and costs should help everyone, in particular injured patients. And so I just really want to accentuate that positive, really, that there are ways forward. It is very difficult, but there are ways forward with it all. In terms of the second part of the question, the claims, again, I agree with everything that Suzanne has already said, really. I don't see the issue being, which I think in particular some of the indemnity organisations are focused upon, that there's going to be this deluge of claims around COVID itself. I think claims in respect of delay in diagnosis and treatment of COVID itself, I think are very difficult. For obvious reasons that Suzanne's alluded to, you can well understand that the courts are going to have a lot of sympathy with a trust that says, well, look, what else could we do? We were in the middle of an unprecedented pandemic that we haven't faced in the best part of a century. And I agree with Suzanne that actually where the issue really lies is with the cases around COVID. So the delays in diagnosis and treatment of cancer. You know, as Suzanne referred to, all the experts are talking about, in essence, a tsunami of cases around delays in diagnosis and treatment. And I think that's where there's going to be more probably claims and more being done in relation to the pandemic.
Thank you, Paul. I mean, it's really pleasing from sitting on the outside to see the collaboration that's taking place, and to see that we are trying to work with the patients at the heart of solutions. From an ATE perspective, particularly that interests me, the limitation point that was negotiated, it was a big issue for ATE insurers, because issuing protectively on this cases without the required evidence would increase the potential exposure. So it's a really good point, and pleasing from our perspective anyway, and I'm sure from many clients that is in place. If I could move on now to Steve Webber on the same questions, please, Steve.
Yes, thanks, Mike. Well, on the effects of COVID, obviously they've been dramatic across society as a whole, let alone on the legal profession. But certainly we saw initially the delays were quite immediate when the pandemic started. New inquiries stopped pretty much as soon as the first lockdown happened, which would have been expected. And also we found that there were delays almost immediately with medical assessments which had to be cancelled, and all of the rest of it. But things did settle down. One thing we found was that settlement meetings didn't get adjourned or postponed, because both parties felt that we should proceed, and we moved immediately to virtual RTMs, and that was really successful. So we found that our resolution rate didn't change. We found that a lot of cases resolved on a virtual settlement meeting, which was great for clients that was their big worry initially, I think, because they thought their cases wouldn't be able to be resolved until the end of the pandemic. So that was a positive. There was one slight negative about virtual settlement meetings. I think clients often found they didn't have that finality that they sometimes get when they meet in person, and they were in your office and they knew that the other side were there, and it felt a bit more real, I think, more like maybe the, in inverted commas, day at court, that they had that sort of final day resolution. So whether we are going to remain at this sort of virtual settlement meeting after the pandemic, I'm not so sure. So I think clients will want to have that personal touch for such an important issue. But you could see how it could work on lower value cases, on mediations and things like that. It has worked pretty well. What we did find is they weren't any quicker, which we found quite surprising. We thought that a virtual settlement meeting might be all over by lunchtime, whereas we had quite a few that were running past Coronation Street. So that was a strange thing, that we thought it would speed things up, but we still had those delays. Less small talk with the clients, because they tended to go off and come back. But it was a different experience, but a lot of positives, as well as maybe one or two things we have to think about in the future. moving on from the sort of initial effect, the delays that we found are certainly the medical experts. Obviously, they have a lot of other things to do at the present time. A lot of them are taken straight to the front line, and it's obvious that they wouldn't have time for all of the other activities such as assessments. Obviously, it's difficult to have an assessment in person. So all of that was absolutely true. We found non-medical experts were much quicker. We've had some care reports turned around in a matter of weeks rather than months that it was before, and certainly some of the other non-medical experts have been very quick because obviously they may find that the Zoom assessments are quicker, easier to organise, less travel. All of these sorts of things I think have factored in. So there's been some quicker assessments and some slower. So we've seen all of that. The courts certainly struggled initially with certainly some of the regional courts. Their IT may not have been as good as it could have been. They struggled with electronic bundles where they were before very much paper-based. We found that's improved, but still we're getting quite a lot of delays, quite a lot of variety in responses. Some courts still want in paper. Sometimes the district judge wanted electronic, but the court staff insisted on paper, and we've had quite a lot of issues around that. It's improving, but there's still issues. Obviously, there were delays in getting hearing dates. We had a cerebral palsy trial in person in the RCJ, the first one last summer. The defendants applied to adjourn that, then they applied for a virtual hearing, and then eventually it went ahead in person, and that worked very, very well, very safe, and it was a good outcome for the client to have their day in court for that. So that was a positive. That there are different ways of doing it. Some hearings can go ahead virtually, others maybe it's better in person as long as it's safe. So all of that has worked well, I think, generally, but there's obviously issues there. We have found that many lawyers are using COVID as a blanket reason for delay, and I think, as Suzanne and Paul said, not all cases have to stop. Cases can proceed. So I think you have to be careful if when a response is immediately, oh, it's got a delay because of COVID. Well, does it? And think about it. And some will have to, but not all. So I think the use of that sort of blanket reason has got to be investigated a bit further. The one other thing is we found that inquiries have increased. New client inquiries have increased over the last couple of months. It was very, very quiet. And I think most of these are historic. I think the concern over this, as it's been described as a tsunami of claims over the treatment of COVID, I don't see that coming. I think the public have a great deal of sympathy for the courts. Well, I think all of us do. I think the actual treatment of patients going into hospital with COVID is not an area that is likely to cause issues for the NHS. I don't see that. I see, as the other panel members have said, that there probably will be issues sort of not directly COVID related, but in related to delays and issues with treatment elsewhere, which is something we really have to look at coming out of the pandemic now. Those things need to get moving. Someone told me recently that the delays for elective knee surgery and orthopedic surgery have really gone up. In Northern Ireland, they've gone up to a number of years. So that will be a real concern, I think, in the long term generally, and in relation to litigation. So I think that's generally my views on all of those issues.
Thank you, Steve. From our perspective, having a bit of an overview by seeing the cases from our panel of firms, I think I would agree we're not seeing any tsunami of COVID-related cases. The issues that you've identified there, we're very much alive to. It will be interesting how things pan out, but it's very much from our perspective on an individual case assessment to see what has actually taken place. And now I think it'd be really interesting to hear the views of the bar on this. So if we could move on to Shahram, please.
Yeah, thank you, Mike. I think I'd like to echo Suzanne's sentiments in terms of my gratitude to everyone on the front line and the NHS, and of course all the services that go to support those frontline workers. They've worked under quite extraordinary circumstances, and I think that does need to be recorded. In terms of how things are working actually at the coalface and the courts, I echo Steve's sentiments that the courts did initially struggle at all levels, whether it was your district judge at the county court or your High Court master. And that wasn't because of any lack of motivation, but it was simply because the systems simply weren't set up and ready. And of course, the court staff weren't appropriately trained and didn't have the resources. But just under a year on from the very first lockdown that we had, things are working extraordinarily well, certainly insofar as telephone and video hearings are concerned, taking it from your initial cost and case management hearings. They're working now fairly well and almost as good as in-person hearings, and also approval hearings. So after settlement, and when otherwise you would have turned up to court with your client and the other side, judges are now doing those sometimes at home, sometimes sitting in their chambers at court, and they seem to be working extraordinarily efficiently. Where, however, there are still challenges, in my view, are the following areas. Firstly, when you're dealing with multi-trust, multi-party claims, you may have one party who is perfectly well set up in terms of, for example, giving early access to records and scans. But that doesn't necessarily apply for all trusts in different areas of the country who are undoubtedly under different pressures. And that tends to cause enormous delay for, whilst you may have records for one party, it's very difficult to investigate the overall claim in terms of breach causation and or quantum unless you have documents from everyone. The second area where there's invariable delay is, again, as our other panel speakers have talked about, is access to the clinician to take witness statements, to get them to provide their views of what has happened. And something that Peter may come on to in a moment that I've seen delays of as well is at the very early stages of an investigation, the serious injury investigations are delayed because of the very same problems of access to the clinicians. And therefore, victims of misfortune during treatment do not even have that initial indication of understanding what went wrong and why something went wrong before they can even go to a lawyer. So those are specific challenges that I've seen. And then again, what Steve said, I came across only yesterday on two separate cases, whereby there was a blanket request for a 10-month stay and a 12-month stay, respectively, because of difficulties of two separate trusts having the ability to instruct and get reports from their own experts. Now, these are cases where we sent letters of claim in the early part of 2020, so even before the first lockdown. And when my instructing solicitors have respectively gone back to the trust and said, well, what have you been doing for the last year or so? We've simply been faced with an explanation of, well, it's COVID. And I just don't think that is a genuine argument in most cases. It is, of course, genuine in some cases. But to end on a slightly happy note, ADR is still effective, it's still working, and in fact is being more utilized since the first lockdown, because the cases where both parties take a view are capable of an early resolution on any of the outstanding issues are being resolved. And I think that from a patient's perspective and also from a frontline service perspective can only be a positive.
Thank you. I think that's a definite interesting point that we'll perhaps come back to regarding ADR. I'd be interested to hear the panel's thoughts on how that has been affected. Obviously, the reason we're all here is the actual victim of medical negligence. So I think, Peter, if you could put their perspective forward on the current situation.
Thank you very much, Mike. I'd like to start by saying, well done to everybody in the system. Of course, to the NHS and healthcare and social care staff, frontline workers, but within clinical negligence, during very challenging times, people have kept the doors open and kept things moving on behalf of injured patients and their families and justice in general. We too, as a charity, were extremely challenged, but have managed, like you, to adapt and keep our core services going. We did see initially a very big drop in the number of inquiries of people coming to us for help, but that actually recovered before the end of the year, and continues to be at the kind of levels we would expect. Right at the early days of the pandemic, from a patient safety point of view, we were ringing alarm bells about the treatment of non-COVID patients. And to be honest with you, it was very, very hard work to get that issue taken seriously. Understandably, perhaps because of the urgent focus on the pandemic itself and treating patients with COVID. It took months before we could drag a strategy out of the health services in England, Wales and the rest of the UK. There is more recognition now, but I don't believe it's being given anywhere near the priority that it requires. On some estimates, the damage, the harm, and indeed the deaths from late diagnosis, delayed treatment, or complete non-treatment of people with conditions other than COVID could be on a similar scale to the death and harm we see from COVID itself. Yet we don't see regular statistics about what's happening for those people in the same way that we do COVID. We don't, frankly, get the same sort of compassion showed by politicians, by the Prime Minister, as has been expressed for staff and for patients and families affected by COVID, directed towards all the other people who are suffering. In some cases, inevitably, but arguably in a lot of cases because of poor planning, and more could have been done. So in terms of what this might mean going forward, like the law firms we've heard from and our own members, we've not seen a huge number of inquiries specifically around COVID, or indeed specifically around non-treatment or diagnosis because of COVID. There's a steady trickle. I think that whilst there isn't going to be a sort of tsunami of claims, as some alarmists have suggested, there is going to be some catching up to do. I think that people are very reluctant to raise concerns at this time. And as has been said, the NHS itself is way behind on looking at incident investigations, and even complaints, where at various times they've actually been put on hold. So even if people suspect they've been avoidably harmed, there's going to be a delay and then a catching up. The other question is, how many people will just never know, or never think to ask, and simply assume that this is all inevitable because of the crisis that the health service has been trying to deal with. Great credit also to law firms, I think, for approaching this whole situation so sensitively and showing respect for the challenges faced by the NHS. You know, we haven't seen ambulance chasing, grotesque advertising, etc. And I think that's appreciated by everybody. One of the big fears we have about the future, moving on from COVID, is that it could create the perfect storm, if you like, for people who already had it in their minds to roll back access to justice, to do that and go further even than was being discussed before the pandemic. We've had an even greater outpouring of love and respect for the NHS and for healthcare staff as a result of the pandemic than existed beforehand. And we all know that people are actually very reluctant to complain or to claim against the NHS. That's been noticeable during the pandemic. Whether that will change over time when people begin to realise that actually, yes, they were under pressure, but they could have done more and should have done more to prevent my particular harm arising. But in that context, the government may feel emboldened to say that with fixed costs, which we'll discuss later, we won't just go ahead, but we'll go harder and deeper. There are a range of other threats to access to justice that we see around the corner. And as Suzanne said at the beginning, already some more extreme parts of the defence side of things in clinical negligence are even arguing things for, complete exemption from liability. NHS resolution are taking a much more measured approach, and I won't speak at length what other people have mentioned, but we're very pleased that AvMA, SCIL and NHS resolution managed to agree the clinical negligence protocol, which our members are telling us is a real help in these difficult times. But it's these fears about what things might look like going forward when the government get round to thinking about it in terms of access to justice, I think, that's keeping me awake at night.
Yeah, I think that's wise, and I would imagine the fixed recoverable cost section that we're going to have with our next question will focus on that particularly. I think from what you're saying there, Peter, I think the human tragedy aspect is something we can't overlook, whether it is whether it's because there is a claim, because it comes from failed to diagnose, misdiagnosis, etc., because of the delays, but also the fear of the person in the street who didn't go to their appointment, who felt scared to go to the appointment and may not have a claim. I think we're going to see that side of things over the years ahead. So I think it's a point well made there, Peter. I wanted to pick up on something regarding ADR and mediation that Shahram mentioned. I was looking at the NHS resolution annual report. And one of the things that came out of that really struck me, that out of 16,000 settlements, only 400 went to mediation, of which 74 actually resulted in settlement. I was wondering what the panel's views were on mediation and whether COVID has affected that in any way, or whether the progress and can move forward and we can this form of settlement will increase. Shahram, if I could refer that to you then, please.
Yeah, mediation, in my experience, works best when you have the parties all in one place and the mediator speaking to both parties and spending his or her time shuttling between the two in order to narrow down the issues. I have certainly not had a single mediation that has been carried out virtually. Not that to say that it is impossible, but it would certainly make it extremely difficult to do, both from a patient perspective, because I think our previous speakers were saying that there is quite a significant value that we can't forget of an individual who is part of the case and the individual who is ultimately at the heart of the case, feeling that they have had a fair opportunity of having their issues heard and dealt with, whether at trial or indeed at mediation. And I'm not sure, and I've carried out trials online and also physically in court, I'm not sure that actually online trials are the answer going into the future. But going back to the issue of mediation, my strong view and experience is that the greatest value of that is when parties are in one place. And for example, an apology can be made face to face. And you really don't have the same value with an individual such as the panel here. If I'm the victim and Peter's saying, I'm really, really sorry, it would mean far more to me if he's sitting across the table from me than on the other side of the screen. So that's the one aspect of mediation, which I'm not sure is necessarily set up for the online future. Then there is the other aspect of making sure that all the dates work with every individual to be able to set up a mediation. And that can sometimes be just as difficult as it is trying to organize a date for a trial. Whereas it's much simpler with, say, joint settlement meetings and or with simply paper offers being made and negotiations being had. So maybe that's probably why mediation is not necessarily working as effectively as it perhaps was.
Thank you, Shahram. I'm going to have to give Paul the final word on COVID and mediation. So if you could respond, please, Paul. Sorry, Suzanne.
Yeah, just to pick up the mediation point, following on from what Sharon was saying, with mediation, it still remains the case that you still need a lot of information to be able to mediate. You need to understand the strengths and weaknesses of the case. So the COVID issues with mediation don't go away. They are, in essence, the same. And the other thing I'd say about mediation is, it's talked about like it is a silver bullet, and it's useful, but it's not a silver bullet because not every case is suitable for mediation. And so I just wanted to make that point, that that could be the other thing, that there's a bit of discernment around mediation. I think when mediation was first introduced by NHSR, it was viewed as a bit of a silver bullet to get them out of a bit of a hole around the amount of cases that they weren't settling pre-issue and then the amount that they were settling post-issue. And I think there's a bit more discernment around that on both sides about, as I say, that there are, only some cases are suitable for mediation.
Excellent. Thank you very much, Paul, and thanks to the panel for your update there on COVID. Some of the questions now will be moving to a live Q&A, and some of the audience will hopefully have some questions, so we might get a chance to expand on the answers that you've already given there. And that is the close of the COVID section. Okay, as we move on to our second question on the subject of fixed recoverable costs. Talk of fixed recoverable costs for low-value clinical negligence cases has gone very quiet during the pandemic. What do you understand is the present position, and what do you envisage the next year will look like? And is there still an appetite for the government to implement the CJC recommendations? If I could direct this question first of all to Paul, please.
Yeah, thanks, Mike. I think probably the first thing I'd say is not just on fixed costs. It's a bit hard to discern the government's appetite on lots of issues at the moment. But certainly in respect of fixed costs, on the face of it, it's been quite quiet. But SCIL is still working very hard to oppose fixed costs, and we're probably unique as an organisation in doing so. And so there's lots still happening behind the scenes. Officially, the consultation is still imminent, whatever that means. It's been imminent now for the best part of 18 months. But just recently, we have had a bit more noise around the issues. So we've had a bit more noise from the Department of Health and Jeremy Hunt, in particular, asking one another rather leading questions and giving rather leading answers. And the all-parliamentary group First Do No Harm, there was some allusion to fixed costs, and there is a feeling that perhaps this noise is a precursor, perhaps to the consultation now coming out fairly shortly. Certainly in SCIL's discussions with the Department of Health, we have secured an agreement that the consultation will be an open one. And what we understand by that is that whilst it will be a consultation around the CJC report, it will be possible to put forward other alternatives to what the CJC report came up with, which of course SCIL and in particular Steve and I were and Suzanne were involved in, and Peter as well. And it seems to me, in terms of the CJC report, it's got two real major flaws, and those flaws are that it doesn't deal at all with patient safety, even though that was one of its very clear terms of reference. And that is one of the real issues here. We need to increase patient safety learning to reduce the number of claims, and that would be the much better start around reducing the overall clinical negligence bill. But also, and I know, Mike, you'll be very interested in this, there was no real consideration of the need for and the ongoing role for ATE cover in any fixed cost regime, which there will be, and there was no real discussion around that. it seems to me that the underlying problem is still the same, and that is that lawyers' costs aren't actually the issue. And if you're focused on lawyers' costs, you're looking in the wrong place. And we know that from NHSR's own reports, because for the last 2 years, claimant costs have in fact been reducing. So that is not the problem. The problem are the claims, the instance of negligence, and so the lack of patient safety learning, so the same claims coming around time and time again, which we need to get on top of. But rather than just sit back and say, well, fixed costs, no, SCIL has come up with an alternative scheme, not least because I think most claimant lawyers agree that the process for lower value claims, I just want to make the point, just because a case is lower value doesn't mean it's of low importance. It's of great importance to the people it involves, and it's also of great importance in terms of a patient safety learning opportunity. But for those lower value cases, I think it's accepted that the current process is quite cumbersome. And so the SCIL scheme looks at a different process for that. And what we say is, we'll try that first. Let's pilot that, review it, and see if we've then got to go to the extreme of actually fixing costs with all the access to justice issues and the patient safety learning lost issues that has. And so really, my position still is that the aim, rather than fixed costs, should be to fix the process, review that, and then see whether or not we have to go to fixed costs.
Thank you, Paul. I think moving on, I think you'd be interested to go to Peter at this stage to have the client's perspective, the victim's perspective on the fixed recoverable cost reforms.
Thank you. We've always been strong critics of the fixed recoverable costs proposition, not because we don't think it's reasonable that costs are kept as low as reasonably possible, but because they're based on false assumptions about claimant solicitors' costs being, beyond the pale. And in fact, we did a freedom of information request to NHS resolution asking, in cases of £25,000 value settlements and or less, how many objections had they made to the costs being claimed, and they couldn't even tell us. They're obviously so small in number, so minimal, that they don't even bother keeping count of if they've chosen to challenge a claim on costs for low value claims. I think it's more of a knee-jerk reaction based on the perception that the NHS simply has to save money wherever it can. A senior official from the Department of Health uses the phrase, we need to strike a balance between access to justice for the harmed patients and the cost to the NHS. And because the words strike a balance are used, people can be understandably led to believe that this is a completely reasonable statement. Actually, if you burrow down or just look slightly behind the words, what's being talked about is not really balance. It's moving things in one direction. It's starting with the assumption that all of the work that's being done on patient safety is not going to make a significant difference. There is not going to be any significant drop in the number of avoidable incidents seriously harming and killing patients. A completely defeatist, what is the point? We can't do anything. And the other assumption that is made is that in order to meet that cost, the only way on saving on that is by saving on people's access to justice, either from taking it away from the lawyers who would otherwise be able to represent and support them, challenge the original denials and defences, or directly by preventing them being able to make a claim at all. or indirectly preventing them to make a claim, or capping the damages that people can have, in higher value claims, etc. And the other assumption that's made is that it's okay to do that, to effectively be saying, rather than putting more money into the NHS to invest in patient safety improvements, to increase staffing levels and overall expenditure per head of capita to something nearer the levels that other Western developed countries put into their healthcare services. Rather than doing any of that, you save money, but you save money, and this is the critical point, I think, and something that we have to make people understand. The assumption is that it's okay to save money by taking access to justice away from the very people who we have harmed, we the NHS has harmed, through our own failings. And I think when that's explained to people, you see a very different response to what otherwise might seem a reasonable point of view, that the NHS is under pressure, this is all taking money away from frontline services, there is nothing else we can do. There are other things that can be done, and we have to keep up the argument. And the only way that we can win this argument is by focusing on what it means to the people at the end of this, the patients and families, who not only are harmed, but they then suffer a second harm by the way that society or the NHS responds. And a denial of access to justice, I think, would have untold damage, not just for those families, but the whole relationship between the public health professionals and the NHS.
Thank you, Peter. I mean, sitting on the outside, looking in, it's very much that the point on patient safety really does need to be addressed and considered, and that is the major area that I look at to think about, to make sure that this isn't just some kind of easy fix to patient safety, and it does concern me a little bit. But I'm really interested to hear Suzanne's views on this subject.
Thank you, Mike. I certainly agree with actually a lot of the points that have already been made. Government reform hasn't gone away, so the feeling of it having gone a bit quiet over the last year, I do feel we are certainly in a bit of a calm before the storm when it comes to reform. And as we've already heard from Paul and others, that there have been calls for this in the autumn, and the conversation is starting to be had. I also agree with Peter's point earlier in the previous question that a factor is society's feelings towards the NHS, because that's influencing government policy and will affect the pace and demand for change and the drive to do that. And the heightened demand on the NHS itself may serve to bring this closer to the fore. So we'd understood from our previous position, a whole sort of 12 to 18 months ago, that a consultation would follow from the Department of Health specifically. And it wouldn't surprise me if this came through this year, 2021. I'm wondering whether it will be part of a wider consultation, bringing in a number of issues together. So it might look different to what we may have been expecting when the report actually came out. So that was in October 2019. And at that point, it highlighted, the report itself, just how many questions remained. Even after substantial discussion with all of the organisations represented today, plus many others, including the judiciary and those representing experts, it's obviously an area of law where there are lots of different influences and organisations, and it's really important that we take into account all sides of this, including how claims can be facilitated and brought through funding and so on. APIL's position continues to be that we must have a fixed process before we fix costs, and that has to be the right way round. The big questions that remained were, again, as others have quite clearly put those points forward, we must connect learning from errors in medical practice, and crucially, we must see evidence of that learning. At the moment, and since the report came out to this point, we have heard of some initiatives focused from the NHSR and other bodies in terms of learning, and they've been very welcome. But what I'd really like to see is evidence of that learning having happened and what's next. And we need to hear of improvements actually being made. So we know improvement is possible. And coming back to Peter's great point, this is not something that we consider is impossible. It must be possible for there to be better medical treatment. We have seen some great initiatives, so Get It Right First Time being one of them. That has been providing data that we can look at and see a measurable improvement in a particular area of practice. So it would be fantastic to be able to see that further development of that. Something that there are big questions around, still remain around exceptions to the scheme, where it just isn't really appropriate because of the very sensitive nature of particular cases. And we all want to make sure that if it is a process that can be fixed and we get to the point where it's possible and it would work to fix costs, that they have to be at a level where specialists can continue to act for patients. We all think that that's something that's incredibly important to provide proper access to justice. Something that Peter raised, which is what I agree with, was that the starting point was a false premise, and we talked about that a lot when we talked in the CJC and as the report was prepared and so on. We talked about the data point where we began, and the recommendations that kicked off this process actually were based on data that go way back to 2015, 2016. That then led to a consultation, the first one in 2017, and then the working group and organisations were looking at 17, 18 data. And as more time passes, I think what's incredibly important is that we must review that, look at more recent data to make sure that the evidential basis remains for changes proposed wherever we are over the next year or so. And of course, court budgeting can't be ignored. There are other things going on, and think the position has evolved somewhat. Something I'm also mindful of is colloquially Jackson 2. So the extension of fixed costs around the position that we're talking about. That was consulted on 2 years ago, though is still on the cards to be implemented. And as consulted on, it would only affect some clinical negligence cases. So those narrow cases where liability was admitted above the 25,000 anticipated value of the separate scheme that we've been discussing, and under £100,000, where there's a limited need for expert evidence. But I'm sure that the arguments from defendants would be put forward, particularly at case management time, of whether or not this was a case that was suitable for that scheme. And I'm sure that it will be raised in conversations and in court hearings. Another area of reform is certainly the other thing I'm thinking about is HSIB. The bill is perhaps more progressed than many in terms of how that role is extended, and a patient and their family's access to information that arises during a HSIB investigation. So there's a lot to talk about. There's also, of course, many changes that have occurred in the maternity arena as well, in terms of the early notification system. And I would just argue that we need to make sure that documents and information are available to families, and they're very much embraced as part of all of these processes, and that they continue to be signposted and directed towards independent legal advice through all of these schemes.
Thank you, Suzanne. Yes, it's interesting, isn't it? You mentioned the starting point there, and I'm looking at the improvements that seem to be made, the cost budgeting improvements, proportionality arguments affecting the cost base, and all of those should not be ignored when we're looking at a massive shift in the cost function of lawyers. So yeah, it's definitely interesting, and I look forward to what lies ahead. Shahram, if we could have your views on this, please.
Yeah, of course. I think the reality is the changes will come in at some point, especially more so given the amount of money the government has been pouring into, which inevitably is going to mean there's going to be shortfalls elsewhere. But we've got to also appreciate, and this is going back to one of the points made earlier when we were discussing COVID, this concern, this worry that there's going to be suddenly this deluge of claims that will arise because of COVID is simply, in my view, wrong. It's wrong because it's based on the assumption that claimant solicitors and lawyers litigate every single claim that comes through their door by way of an inquiry, and that isn't the case. Some will not go much further than the initial investigation, but what that does create is a sideshow of potential learning. And learning is, again, going at what others have said, extremely, extremely important, and it does happen. Just to give you a classic example, I dealt with a very tragic case about a year ago involving a baby who died at a well-known children's hospital on the operating table undergoing a routine operation. And there was a specific gap in the processes of learning in terms of how to put in a tube. The hospital took this so seriously and pushed for significant changes, not only to their own processes, but to national guidelines and also to European guidelines to prevent something like this ever happening again. Now, that's just one example, and I'm sure those on the panel can probably point to a number of examples in cases of theirs where changes have been brought in fairly successfully. So change does happen. But to my mind, the critical factor of any fixed recoverable scheme that comes in has got to be this. One, that it must allow for effective investigation of an access to justice point. Secondly, it's got to ensure that any claimant is able to recover 100% of the damages that he or she is entitled to. Not 60, 70% because lawyers are unable to recover costs into parties because of the restrictive fixed nature and therefore want to claim against damages. Again, that's important because that's access to justice and that's fairness of compensation. And thirdly, and most importantly, lawyers who work on these cases, which are mostly front-loaded in terms of effort, spend a lot of time investigating the claims, trying to find out what happened, why it happened, and whether what happened has a fault nature or aspect. Be entitled, haven't they, to a reasonable sum of money by way of costs for the work that they do. And I don't think anybody can say or is saying on whichever side of the fence we're on that there is the kind of gluttony in terms of cost building, certainly in the low value and the straightforward cases, because I've certainly not seen any statistics. You see global statistics that involve all cases, but it goes back to the data point that Suzanne was stating earlier. We've got to be able to have proper information, proper data in order to analyze the three key factors: effective investigation, 100% compensation principle being maintained, and a fair value of costs being recovered by claimant lawyers for the work that they do.
Thank you, Shahram. That's really interesting to hear your views on that. It's something that we see, but I agree totally with regard to front loading and gluttony. The current cost regime doesn't allow for that to happen, so I think it is a misnomer for that to be out there. Steve, if we could move on to yourself with that question, please.
Yes, thanks, Mike. Yeah, I agree totally with most of the comments that have already been made. The focus was wrong on costs. It should have been on access to justice. It should have been on learning. It should have been on patient safety. But that seemed to be something that there was a feeling from the NHS side that this was the wrong forum for that, which I think is totally incorrect. Any chances to improve patient safety and to learn should be taken. And I think this is a perfect forum when allegations of a mistake are being made, that they should be investigated, even if it's a near miss. Then there are lessons that can be learned. So it seemed a totally incorrect view to me. With regards to the forms going forward, the fact that things have gone quiet, I just think is COVID related. It's just there's so much on the government's mind at the moment that's not related to this, that they're focusing on that. But once that's over, I'd be very surprised if this doesn't come back onto the agenda, and therefore we do need to keep up our arguments against fixed recoverable costs. If that's your view, that's certainly my view, or even against the reforms of it. So I think it's important that we all have that on our focus. I think going forward, the biggest concern that we should be having for patients is creep from this position. They're saying it's fixed recoverable cost now. What's next? Is it then increasing that limit to a higher limit? Is it then moving on to litigated files? Is it then moving on to indemnity issues and tort reform and all of these things that are getting some rhetoric, particularly from the medical defence indemnity organisations, that they seem to be saying it should be other limits on much, much more serious events. Also the rhetoric around these aren't serious events. Well, they can be. They can be devastating events for the families and the patients, and to try and belittle it by saying that they're not is not right. And also it's a confidence issue of the patient to the NHS. If they're feeling this is not something that's been properly investigated, their confidence goes to the NHS, and that's a really big problem for the NHS. So I think a good complaint stroke litigation process for all of these issues is really important, and certainly being based in Wales, we have had a scheme, a low value fixed cost scheme for a number of years, which has been very, very poor and has not helped patients and has increased concerns over the way the NHS investigates matters. And the redress scheme has been a disaster from regards to the patient, in my view. My firm rarely take cases now to investigate through redress because of the problems of delays and the fact that we don't feel it's an appropriate process for patients. They're not getting anything out of it. And if there is an option between that or to go straight into litigation, most lawyers are advising that litigation is a better way to get the answers that the patient is looking for. Because if you go into the redress process, you're likely to sit there for a number of years without the answers you're looking for. So I think the fixed recoverable cost scheme, it is very important that it's right. And it's right for patients, it's right for the NHS, it's right for specialist lawyers. But if specialist lawyers aren't involved, there will be a problem. This will not, the answers will not be obtained. There will be delays in the process. There will be all sorts of problems. And eventually, where all of the focus seems to be on legal costs, which is totally incorrect, what we'll lose is, as Peter's mentioned, we'll lose access to justice and we'll lose a chance to improve patient safety, and that's a chance lost, which is a crazy thing for me. There was a real opportunity here, and it will be missed unless there is reform to the process that's being suggested.
Thanks, Steve. Yes, I couldn't agree more on many of the points you made there. Paul, you'd like to comment?
Yeah, sorry, I just wanted to pick up a point that both Suzanne and Shahram alluded to, and Steve has also just raised, and that is that one of the main problems here is that the government may be about to shoot itself in the foot, because if they fix costs and specialists do depart the market, as is likely, I think, if what the skill specialist members are telling me would happen, at the moment, we as firms are screening out 90% of all potential cases at the new inquiry stage. Well, if we then step away from that, that's an awful lot of cases that NHS are going to have a process to deal with litigants in person. That's going to cost far more than they're going to save through any rather blunt fixed cost scheme.
Yes, it's an interesting point you make there. Just by opening the door to or having a fixed cost scheme doesn't mean that there'll be any reduction in the number of claims. They're just going to see more cases that aren't successful, and so it's going to create more and more backlog. So I tend to agree on that point. As there are no hands up, I think that will bring us to the conclusion of the fixed recoverable cost section, and we will move on to the live Q&A on this section. Okay, so our final question today is around funding. At ARAG, we're seeing more and more firms struggling under the pressure of funding disbursements and looking for solutions. Do you feel this is an area of concern, and what are the options for firms and their clients? If we could start with Steve on this one, please.
Yes, thanks, Mike. Yeah, it's a big issue. Certainly within SCIL, this is an issue that's raised frequently as to how firms fund disbursements. It can be a huge drain on cash flow for firms. Historically, it's always just been funded by the firms themselves. But I think as delays during this COVID period have shown, when these delays happen, it means you're holding those disbursements for longer and longer, and it becomes a much bigger issue for law firms. And the cash flow effects, particularly if you're a small firm and you only do claimant work, it can be a real problem for these businesses. Fortunately, there are a number of solutions, but none of them without risk, none of them without their downsides, and you've got to get a balance. And certainly what I always recommend to anyone who asks me is try and use a number of different methods to manage the disbursements, to try and get to a level that your business can cope with, and to provide the support to patients, because most patients aren't able to fund the disbursements themselves, so it does come down often, almost exclusively, to the law firm. So just to give you an idea of some of the options available, most firms will use agencies to some level or other. It doesn't work for every type of case or every type of expert, but it can be something that you can use to assist you with expert instruction. I know a number of firms prefer not to use agencies, a number of firms do. But if you can find yourself a really good agency that's got really good client care, that engages well with the experts, because the experts are so important in these cases, but keeps them informed, make sure they obviously pay the invoices and manage the process well, then that can be a really helpful way of managing the disbursement spend. So agencies are certainly worth looking at, as long as you get a good quality, financially secure agency. So the other option, of course, is to pay it yourself out of your, historically out of the overdraft, but also there are funding schemes available where you can fund the disbursements separately. That is a cost that comes down to the firm, but it may be a cost that it can be managed into your business plan and to move on with that. So it is an option to keep it off your overdraft in a separate scheme, so you keep your overdraft for the capital expenditure of the business, which can be done. Also, you can use that fund then maybe against, when you get an admission of liability, you can use it to have money on account of the fees that you've expended already up to the admission before you get a payment on account. So that can be done as soon as you settle a case. You can also be used at that stage to fund not only the disbursements, but also fees that can help cash flow generally. Those tend to be quite expensive, so you have to bear that in mind. And that, as I said, there's usually a downside to most of these ways of doing it. Strangely, the overdraft tends to be the cheapest way of doing it, because you tend to get overdrafts at quite low rates. So that's all that we weighed out. But then there is an effect, obviously, on the capital that's available to the firm. So it's a tricky issue. Consumer credit agreements were often seen as the solution to it all. My firm brought the case, the Jones case, many years ago, which allowed you to recover the interest on consumer credit agreements. But of course, we've also brought the more recent case of Nosworthy that has not been so helpful. So it is not a clear picture as to whether you can recover the interest. So you've got a number of downsides to this. The client has to sign up to a credit agreement, which is always difficult. You've got a vulnerable client. Do they want to sign up to the scheme? It's not generally the best sort of conversation to be having in this environment around credit agreements, the Consumer Credit Act and all of that. So there are clearly issues with that. Some firms will guarantee that they will that there's a cap on damages, therefore it won't affect the client if they hit the cap. You can give them reassurances, but it's not ideal. And if you can't recover that interest, then who pays it? And often it'll be the firm that will pick up that tab in relation to whether it can be recovered from the client or not, out of damages successfully. All of those sort of things come into the balance, and generally if there is a cap, the firm can end up paying it because they're lowering the cap of recovery. So it is difficult. I think the issue of recoverability of the interest has not ended. The Nosworthy decision is not a higher court decision. My firm certainly do not agree with that decision, and we will be looking for the right case to take further to get some a proper judicial assessment of it. A lot of people will have seen the senior legal comment upon that decision, where the view of many senior cost counsel is that was an incorrect decision, and that why should commercial litigation be seen differently to clinical negligence or personal injury litigation? It just doesn't seem right to me, particularly when the claimants in personal injury and clinical negligence litigation tend to be vulnerable and can often be on low income. So why shouldn't they be able to fund that and have the cost recovered in the proceedings? That seems inappropriate. So if that were to become, if higher court decision were to become available on consumer credit agreements, that may be the solution, because then it would be recoverable, and that is a much better way to fund it overall. It's off the balance sheet for the firm. The client knows that it's recoverable. It's a much better process all round. So that is a way to do it. Now the final bit of advice is move the cases along, because the quicker that you can resolve the cases, it's much better for the patient, and also it's much better for you because you get the money quicker and therefore cash flow is better. There are lots of mechanisms now on payments on account. So if as soon as you have an admission, you can get a payment on account of your liability costs, you can seek to get a payment on account of quantum costs, because there's good case law on that. So all of those issues you can manage in the litigation to get the money as quickly as possible, not only for your client, but also for the firm, so that you can keep representing clients and keep the cash flow going. So it's really important to manage the litigation efficiently as possible and make sure you get those payments on account. It's not like a number of years ago where you just thought, oh, I'll just wait to the end, wait to the end, wait to the end. That isn't really, in the modern world, when you've got so many other pressures and delays on the litigation, once an admission is made, you really do need that payment on account, and the process allows you to get it. So you should push that through. So it's I think you have to use all of those methods to help to balance the cash flow issues around disbursements. 10 or 15 years ago, you'd have said legal aid could help. I'm not particularly sure legal aid can help now. It causes more problems generally than it resolves. And on cerebral palsy cases, you never tend to find you can find the right experts at the rates that the Legal Service Commission will pay. So certainly, I'm not sure that legal aid anymore is much of a help to anyone. It's such a limited cohort of cases, and there's so many difficulties with it that it's almost become unmanageable. So I would say that I would use a balance of all of those things if you can. Some of them are suitable in some cases, some are not. Overall, if you use most of them, you can balance the cash flow issues. Be aware of the dangers of all of these methods, that it could end up being the firm that pays for this. So it shouldn't be the patient. So if it's not the patient, then tends to be the firm will pick it up. If you can't recover the agency fee, the firm ends up paying. It comes out of your costs. If you can't recover the consumer credit agreement fee, is that coming out of your fees? If you can't recover other interest costs, it comes down to the firm. So you have to be very careful with all of these methods to ensure that it isn't a false economy and you end up paying a big price for it. So it's a very difficult, complex issue, which is a real problem for businesses in this arena, and the COVID delays aren't helping with that.
Thank you, Steve. Yes, as I said in the question, we're seeing more and more inquiries because it is a challenge. I'm glad that you believe there are cases where the recoverability of interest can be looked at again, that isn't the end of it, because it did seem an unreasonable judgment. And from our perspective, the legal aid the comment is quite interesting, because we're seeing more and more serious cases where legal aid works up to a point and then it has to move across to CFA just to progress the case and for equality of arms, etc. So we see more and more of those cases from an ATE perspective.
And of course, you also have the ATE providers who sometimes can provide a funding package attached to the ATE, which obviously ARAG can look at for you. So there's those options as well.
Yeah, absolutely. We look at those options. Again, it's a difficult subject, and there are pressure on firms. There's pressure on everybody, and it's generally at the detriment to the clients. So I'm sure Peter will have something to mention about that in a few moments. But if I could just move on to Paul on the same subject first of all.
Yeah, of course. Well, one of SCIL's founding principles was that it would look at how firms function and resolve practical issues. So you'll be unsurprised to hear that having succeeded Steve as chairman of SCIL, I agree with everything that he said. You know, it is a very difficult situation in terms of funding disbursements. And it requires a basket approach, really, all the different elements. You know, legal aid does have a role to play. I can agree completely that it's really difficult to work with, and that's some of the discussions we're having at SCIL with the legal aid agency, is try and iron out some of those practical difficulties and get it to work better. But one of the difficulties I think is that, and it comes back to the decision in Nosworthy, I guess, is where the courts are parting company with what's happening on the ground. Now, the judiciary no doubt would say, well, that's what our job is. We apply the law. You're doing the practical element, but that's part and parcel of the same system. And the Nosworthy decision, cannot stand. We have to get back to the Jones position. There's a practical reality here that there are disbursements to be paid. And as Steve's alluded to, you can't expect firms to be picking that up purely on their own financial shoulders. When we go back to our first question about COVID, we're all under pressure. There are delays to cash flow. And as Steve alluded to, there are things we can do about that. And certainly I would echo what he says about getting payments on account of costs whenever you can. Certainly in long-running quantum cases, the ability now to get payments on account of costs is really helpful to then continuing to progress those really high-value cases. But so I think, we do just need to wait for the case where we can get back to the Jones position, really, because the lesser of all evils, let's leave aside the niceties of the legal arguments and the case law, or at the coalface, the practical reality is the lesser of the evils are CCAs, wherever possible, backed by firms' own funding arrangements, because the commercial arrangements that you can get are far too high. When we're talking about 18% plus, that's ridiculous. That's a worse position in terms of the justice system as a whole, of which we are all a part, whether we're judiciary or solicitors, or we are coming at it from the patient safety angle, as AvMA are. We're all part of that system, and we have to make it work in a practical way that actually works with the person who actually the one is most matters, the service user. I've often said, HMCTS, the S stands for service. We have to remember that there are clients and claimants sitting behind this. It has to be a practical system that works for them.
I think, yes, I'd agree. And it's a perfect point to bring in, a perfect moment to bring in Peter on this one. I agree with everything you say there. And I'd like to hear his views from the point of the consumer.
Yes, obviously, AvMA isn't a law firm. We're not running a business, but we work very, very closely with our members, our lawyer members, who are running businesses. And we hear from them about the pressure they're under. They need to be viable. We talked about fixed costs earlier. I think it's more or less an assumption that for firms to be able to run cases under that regime, if they did, there's going to be some reclamation of costs from damages. That's very unpalatable. Shahram referred to it earlier on, and in an ideal world, it shouldn't have to happen. But if there's no other option in town, those people would want to be represented. But there need to be safeguards, limits, perhaps. But moreover, there should be alternatives to avoid that actually happening, whilst still making it viable for firms that help people access to justice to actually operate in the way we want them to. Legal aid's been mentioned. I'm very familiar from speaking to colleagues and members that there are so many problems with the current rump of legal aid that still remains for clinical negligence. However, I wonder if we should give up on the concept as a whole. Call me an optimist or an idealist, but I still believe the government shot itself in the foot when it took clinical negligence out of scope for legal aid. It still irks me that we ran a very successful campaign, but we lost a vote by just 7 votes in the House of Lords that would have changed that. If we can make the economic case that a properly designed, properly funded, workable legal aid scheme would actually work in terms of economically for the government, as well as for claimants and law firms. I think we shouldn't give up on it. It just makes sense. Of course, what happened with that is that you've got two different government departments. The Ministry of Justice had to make their savings. In actual fact, what they've done is ended up costing the Department of Health and Social Care a lot of money, which we're now hearing them bleat about. There needs to be some cross-government thinking about all of this. And I think if we can get parliamentarians on board in thinking bigger rather than looking at these kind of knee-jerk specific reactions and restrictions, we could get a better solution for everyone. As a fallback position, we've been thinking for some time, if needs must, is there some other radical thing we could do to actually ensure that people don't lose out, they don't lose out on access to justice because of funding issues. Could we have some sort of scheme with the help of a philanthropic bank, to create a fighting fund for people, sort of independent legal aid fund or fighting fund that people could turn to? Could industry invest in that? There are some examples around the world, Hong Kong and other, where various versions of that sort of approach have been adopted. I think we have to have every option explored, but I'd include the really big ones about whether it is doable to get a properly run, properly designed legal aid scheme of some sort. At least perhaps, you mentioned, the early part of cases, Mike. There was a proposal at one stage that you'd get a fully funded legal aid provision for the investigative stage of cases, at which point, if the case is viable, it moves on to a CFA. I think we have to explore all these options.
Thanks, Peter. Yeah, it is interesting. I know from an ARAG perspective, we've looked long and hard at the funding solutions, and unfortunately, one factor is that money costs money, and there is always going to be a cost there. We've looked at the options, and we try and make something that's as affordable and realistic as possible. That's our view on there. But another interesting point you made was cross-department forward thinking and cooperation. I think unfortunately, I'd like to think it exists, but we seem to be a long way away from that, whatever subject you particularly decide to look at. Keeping with the funding though, if we move on to Suzanne, please.
Thanks, Mike. I actually agree with a great deal of what's been said so far, and others have covered it in a lot of detail. There needs to be a route and a workable mechanism to bring a claim, and that's more than money. That's an access to justice point. Funding disbursements is an enormous drain in this sort of case in particular. Experts aren't getting any cheaper in terms of how much those reports cost, and court fees where the client isn't exempt, that's £10,000 a case in larger cases. So this is a lot of money. There needs to be a route to bring these cases, and this is something that actually came up as part of the fixed cost discussions. When we start talking about costs, we do directly go to access to justice. We are currently relying upon a basket approach. We're making do by working out what option fits for your firm. Each firm is different, and again, there's a difference between where a firm has a range of different practice areas and those that solely focus on litigation. Everybody has a slightly different business model. Greater pressure than ever before, and as that pressure increases, they'll feel less able to fund some of those costs than before, perhaps. I suppose when the wider world feels a bit more uncertain, both nationally and internationally, banks take a different, a more nervous approach to things, and perhaps more cautious. Of course they will. When we talk about relying upon overdrafts, that's a bit more tricky, because of course in a more problematic environment, the banks can call on an overdraft to be repaid, and so that might be something that firms don't wish to rely upon to a great extent. I agree, we're all using to varying degrees those organisations and experts who have deferred payment schemes, which are very helpful. It allows us to share out the burden of the weight of those costs, and there are a range of different products out there. At the start, it's an access to justice point, but I completely agree with others when they say that this is also in relation to progressing a case. So what happens when the next bill comes along? Payments on account of costs from paying parties are a necessity, I'd say, to manage the drain on firms. And it's very difficult when they are fought in cases where there is a wrongdoer, liability has been admitted or proven, and yet there are fights in relation to payments on account of costs. It's very difficult to see on what basis. We know that technical points will be taken, but it turns into, again, an access to justice point where you're stopping a progress of a case and a firm being able to progress something. We rely increasingly on insurance products, and thank goodness that you're there, and this ability to share the load is out there, because as we get to the end of this line, the only alternative is to go to our clients, and that's just not going to be possible. They're in a very desperate situation, and they're already being hurt. They lack trust. They do not want to be looking to fund money, pay money out of their back pockets with a risk attached to that. And again, will they just choose not to bring a case if they're asked to pay? It's just not fair. Legal aid is not the solution in my mind. It's not available in the vast majority of cases, and I still struggle to see how a fully contested cerebral palsy case can reach trial whilst continuing under a legal aid certificate, with the limited expert fees, the number of experts necessarily involved to prove your case. The point about this being perfectly possible has been made to me in cases, but I simply don't see how that's possible. And I really do agree that I think there is a gap between what is understood by the judiciary as what's possible and about funding options in cases and so on, and what is actually going on at the coalface. There really is a difference there, and that's very difficult. Going back to what firms feel about making deductions from compensation, I don't know about everybody else, but it's always felt a bit uncomfortable and a bit inconsistent with what we're all fighting for. We want 100% compensation to be available to our clients. We need the funds to be able to make the claims and bring them, but we do want our clients to receive the compensation they're actually entitled to. So that's something that's difficult. That's difficult. It continues to be a sort of inner difficulty that we have. I think it's good to be thinking, as Peter mentioned, of what could be better, what could work. That's going to involve some sort of brave thinking of let's just completely look at a blank slate and think about what's better. But I think that maybe we're working towards a period where we're questioning what's gone before, and we might be at a time which would be helpful to carry out that sort of review, because we're getting by. It's not perfect at the moment, but every solution that's available is helpful.
Thank you, Suzanne. It's interesting, the subjects we've been discussing this morning, they all lead to further erosion of access to justice and more challenging times ahead. And I'm really feeling that during our conversation, and we all have to work together to overcome these challenges. An interesting point you raised, Suzanne, which I'd just like to take a moment to expand on, was the increase in experts fees as well as court fees. We, having a critical mass, have done some work on it, and we've seen over the since 2013, there has been a 5% average year-on-year increase in experts reports. So it's just quite interesting to feed that back to the audience today, that we have that critical amount of data, and it is interesting to see. So I just thought I'd share that with everybody when I had the opportunity. Shahram, if you could bring this section to a close with your thoughts, please.
Absolutely. I'm glad to say, having heard what all the distinguished panel members say about the difficulties, that I don't have that financial difficulty in terms of to work out reimbursement. But something that I do want to say, and I think it is really important as an industry in terms of litigation and also patient groups, is this. Isn't it strange how the narrative in relation to the cost of litigation is heavily weighted in favour of the NHS being seen as the victim of all of this, that they're struggling with the amount of costs that are being charged. Whereas in reality, the relationship between the claimant lawyers, the funding difficulties, problems they face in probably the vast majority of their cases is never fully understood, is never fully aired. And I just wonder how, and this might be for the discussion on Wednesday, but I just wonder how, as an industry, as patient pressure groups, as AvMA are, how we can try and rebalance that misperception that it isn't just the NHS that is facing funding difficulties and shortfalls, but it's actually legal firms. And more importantly, it's the patients who are potentially injured that seek to have redress that may never do so because they're worried that they can't get access to funding. I think it's really important that we try and rebalance that, because it's so skewed in the wrong way from the narrative of the understanding of the judiciary, from the political point of view, and also from a publicity point of view. That where this issue has never really been aired to try and better understand what we have to go through in terms of funding a case versus the NHS. So that's my soapbox argument for further discussion. And I don't know whether our panel members want to add anything to that.
We all fine. I think speaking for the panel, they'll all echo your sentiments there. It's a skewed view on things. It's a very one-sided look at the argument, and we see it, as I say, going back to the question, we see the issues for firms. We see the issues that then cascade down to the clients, and it's a very, very tricky environment for all the law firms at the moment. So I think you're all absolutely right. It is an area for concern, an area to look at, and an area for everybody to work together on innovative solutions. So hopefully that is something we'll continue to do so. Thank you all for your time this morning. We're now going to move on to a live question and answer session. So we'll wrap up the roundtable now and move on to that. And thank you all for your cooperation.